So I'd call our open session meeting back to order, and we need to stand for the pledge. Ready to begin?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
There is not a report out of closed session tonight. Motion to adopt our agenda, please.
I have a request, and I would move that we pull item 12 and move it to our February 6th meeting, because we have to, what?
In the past, that's how we've done it. But
So.
Say it again, what's the order?
So did you second it? And then.
Second it.
Okay, and then make your comment.
Okay. I suggest, I move that we remove item 12, and the reason is, it only has governance and protocols and does not have bylaws, and I know that board member Perry has a lot of bylaw questions and concerns, and I think February 6th would be a great meeting to put them all together. So we have a clear review of bylaws, we have a clear review of governance and protocols and how they all connect.
So would that also include policies?
Well,
Because there were a lot of questions that were policies and bylaws.
Yes.
On board.
So that again?
In other words, like the 900s.
Yes.
Okay, so at our policy meeting then, we would address those policies first, give priority, that whole packet we got.
Yes.
We give priority to the 9,000s.
Right.
And then, because we base our protocols on our bylaws and our policies.
Correct. So
this would be, right now you're saying that tonight potentially we're doing it
backwards.
should.
Yes, that's the way I'm interpreting it.
Okay.
Because if it's not clear for everybody on the board, then there's no point in discussing the protocols because they
Because
They come from the
we'd have
bylaws.
to address the others first before
Yes,
we would address protocol.
that's my recommendation.
so as the motion stands right now, it's to remove item 12 from the agenda and re-agendize?
Re-agendize to February 6th, already scheduled meeting. As after the bylaw discussion. Is that right?
Policy and bylaw.
Policy and bylaw, sorry, I'm not using the term.
Yeah. And giving the priority to the 9,000 series, because I don't know that we would have time at that workshop to give it to any of those other policies that were in the package provided.
Right, we haven't agendized that yet, so we
Right.
have plenty of time to do that. I think that's the interest of the board.
And I'd like to suggest that we look at all 9,000.
And are there more, they were already listed on that?
Not all of them.
Not all of them,
Okay,
okay.
so we just look at all of them, to tell a story and stuff, yeah.
Okay,
But you prefer not to do any policies tonight?
we can.
We can't,
They're not
We have no
agendized.
policies tonight.
This
No,
is
we're
on
not.
agenda.
governance and protocols.
It's only protocol.
And
just this.
all the way to the end of the request.
Okay, is there any, we have a motion and a second on the floor, and discussing the proposal to remove 12 from tonight's agenda and reschedule for the meeting of February 6th, policy workshop. Is there any further discussion?
So are we
I should
amending
ask
the
for
motion?
public comment, is there any public comment first?
I think the problem with that is then it's not available to anybody who isn't here.
Okay,
And I think it's,
I'm not following that. It's not available to anyone who isn't here. What's
It's
not
not-
available?
it's not recorded because it's a special meeting.
Well, I think that can be, I have a request at the end that I think will clarify. Because I had a separate request that I was gonna bring up.
Well, I don't believe that we would be also doing governance and protocols at that meeting. We would be doing the policy workshop.
I don't think you have enough time to do both. So there are, I don't know, a long list of 9,000s. So
And we've
to
allotted 3 hours
to
for
go through all of that, I think would probably take a significant amount of time, so I don't know that you would be able to accomplish both in the same session, potentially, but.
So
Well, and
we
part
just put it at another meeting?
Fritz,
It's a workshop,
It's a
so
workshop.
no action out of those meetings anyways, it would be first read, second read. I
Right,
think
so
after
part of the
the
request
actual
would be,
meeting.
we could then bring it, we
Well,
would
you
all
have
agree to
to
bring
bring
it.
it as a first reading
Right, to
anyway.
bring it back as a first read,
They have to
I
have
think,
the first reading.
I think what you're saying is the governance and protocol, this item, I got you. Number 12 okay, so let me be clear. Number 12, I think is logical to pull tonight because we're gonna review the bylaws. And policies, sorry. And so we wanna do that first because that helps us,
Well, that drives these.
that drives these. So then we would complete the bylaws and then replace 12 at a future meeting when the bylaws have been reviewed and policies.
Well, they have to come and be approved. If we-
Yes,
if we
they
make
have
those
to come and be,
changes.
so it might, okay, so it might not be able to be at the February 6th meeting, but how about post February 6th? Where those bylaws and policies have been,
Re-agendize this topic.
Yes,
Request.
yes.
Of course, we can re-agendize
Okay.
it at a future date.
To come as a first reading on the 12th, then they need to come back for a second reading.
okay, I see what you mean,
And
you're
then
pulling,
after that, we would be able to schedule a governance and protocol
Okay.
session.
that, it makes more logical sense rather than talking about something that may be altered on February 6th, yeah.
So where are we at with the motion?
I'm still discussing it as far as Member Perry's concerned that people wouldn't know about it.
Well, what I meant was it wouldn't be recorded. And I think it's important, to do it in an open meeting.
So the way that
That would be an open meeting.
because you would be re-agendizing it on March 12th or March 26th, right?
No, I'm fine with that. I meant the February
Yeah,
sixth.
yes, I saw it.
So your question really concerns the fact that we have not broadcast our workshop meetings. So.
That's not your question, is it? You just wanted to make sure that.
The governance, she was like,
Well,
this
she's,
topic.
I understood that she's concerned that when we discuss these policies and bylaws on February 6th, that it won't be available on
That's
the
awesome.
recording.
That's been the standard practice.
But that's a practice, having that discussion with the attorney, and go back and forth.
Right.
Right, then everyone has to hire an
And
attorney.
the public it's an open public meeting.
Right, anyone who comes in.
We're concerned is that it should be available to people that only want to listen to the recording and not have to come.
So
Well,
workshop,
it's during the day, so it's a difficult time for people to come.
so I think it's much easier to come in these hours.
I think you'd find it a mix, I think you'd find it a
To be
mix.
I wish all our meetings were in the morning.
So where are we at with the motion?
Thanks, Jim.
Can I clarify what I think
Yes.
you guys?
Please.
So we're removing 12 from this agenda. We're gonna discuss the board policies and bylaws on February 6th, prioritizing the 9,000 series in its entirety, and then doing whatever other policies we prioritize and can get to in that 3 hours. The protocol will be re-agendized for a future date, either March 12th or March 26th, because the board policies will be at first read on February 12th and February 26th. February 12th and March 12th.
That was very logical.
Yes.
That's what we're doing. Yes?
Will we still,
Well, I mean, but not that.
will we still make the protocol meeting a special meeting
It would be interest in the board.
rather than do it within another,
It'd be, that'd be determined at
at
a,
a future time?
Let's have
Any
call for the
further-
question
yes.
on the
All
motion.
those in favor as the motion,
Well, call
they
for,
can no, Ellen's discussion.
no, call for the question has to be second, and then it has to be 2/3 party. Yes, I write it up, and then 2/3,
Seconded?
2/3, all 4 people then have to vote
Okay.
on it. But we were already, I think, anyways, so do we want to vote on that, what you just said, or can we vote on the motion?
I'm happy to let you vote on the motion, I'm just concerned that you're just going into the minutia.
Okay, all in favor?
Aye.
Opposed?
No.
Okay. We have no recommendations tonight. We have public comment on non-agenda items. Anyone? So we move to information item, presentation of the overview of the Brown Act. Mr. Delory, can you listen to this one?
I'm happy to. We have online card here from the firm Atkinson, Hamilton, Boyer, Rudd, and Romo to present on the Brown Act. Again, this is part of one of the board bylaws, which is to provide the board, all board members with information on the Brown Act. Typically, we do it in the form of a book, but it was determined this might be a better and more interactive opportunity to ask questions, because you can't ask questions of the book. And with that, I will pass it off to Ron and let him take it away. It's all yours, Ron.
Thank you very much. It's a pleasure to be here. I've seen some familiar faces and some new faces, so they're great to be here. What I'm going to try to do is not cover everything in the Brown Act because I think we'd be here all night, but just try to give you an overview of some of the most important points. But if you have any questions about the Brown Act, I'll try to answer those questions. And if I'm not able to answer them tonight, I'll make sure we write it down and send you a written response later. So what is the purpose, here we go. So what is the purpose of the Brown Act? In the Brown Act itself, it says the purpose is to give the citizens of California access to government agencies and prohibit governmental decisions from being made in secret. This act was passed, it's named after a former state legislator, Ralph M. Brown, in the 1940s, who was an attorney who went to several city council meetings in the Modesto area and found that, to his dismay, that decisions were being made by the city council in secret, and he couldn't get access to how those decisions are made, and wasn't able to secure that discussion. And so he began lobbying for some type of open meeting law, and then he got elected to the legislature, and then as a member of the legislature, he pushed for what is now called the Brown Act. So it requires that actions and deliberations of the governing board of local agencies be taken in the open and in public. It requires all meetings and deliberations, including discussion, debate, and acquisition of information, to be conducted in public, subject to public scrutiny, except when closed session exceptions apply. So all discussion, debate, acquisition of information is supposed to be done in public. And the Brown Act does not apply to meetings of employees of public agencies. We get that question every once in a while when people want to attend staff meetings or employee meetings. Those are not open to the public. So how does the Brown Act define a meeting? It defines a meeting as any congregation of a majority of the members of the legislative body at the same time to hear, discuss, or deliberate upon any item. So a majority of a 5-member board would be 3 members. So if 3 of you are together at the same time, it's not just discussion or deliberation, but also to hear. So if you start talking about business, 3 of you bump into each other somewhere in town, let's say, and you start talking about district business, it could end up in a violation of the Brown Act if somebody overhears your conversation. So it's a pretty broad definition. It goes on to state that a majority of the members of the legislative body shall not, outside of a meeting, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the board. So you shouldn't be using email, serial phone calls, serial meetings, third parties who might try to build a consensus on an item. It's supposed to be taken at the board meeting where people can hear you discuss it, decide what you're going to do. Similar to what you just did a few minutes ago. You talked about item 12 and whether item 12 should be moved to a future meeting. That whole discussion took place in public. So anybody who was sitting here in the audience could hear that discussion, hear the different opinions of the different board members, the different positions of the board members. So separate communications or conversations are permissible so long as between 2 members is permissible, so long as you don't communicate it to the third. So if board member A talks to board member B, that's fine. But if then board member A then calls board member C and says, hey, I was talking to board member B and this is what we talked about, this is what we agreed upon for the next board meeting, then that would be a violation of the Brown Act. And so this happens, this is where you really need to be careful, is when it comes to emails. Because it's very easy to send out an email and then hit reply to all or send an email to multiple people. That's one of the benefits of having email. You don't have to call 4 or 5 people at one, over and over to communicate a message. You can blast out one email to a whole group of people. But when it comes to the Brown Act, you got to be very careful. So, for example, if you send an email to the superintendent, for example, if you copy all of the board members, and then the other board members start to respond, and the majority start to participate in a discussion, then you've got a Brown Act violation. So you have to be real careful about, better?
We don't have anybody here, so you can actually take that. He doesn't need it. Just take it, because he doesn't need it actually,
Yeah.
it's only for
Oh, okay.
broadcast and everything.
So can you hear me okay? Okay.
Yeah.
So the next slide kind of illustrates that. It says board member A sends an email to board member B. Board member B responds to board member A and copies board members C, D, and E. So if we step back for a minute, board member A just sent the email to board member B, and board member B just responded back to board member A. That would be okay, that would not be a violation of Brown Act. But when you get to that second bullet, and the board member B responds and copies board members C, D, and E, now you've got a problem. Now you've got, you're on the verge of a Brown Act violation, and then when board member C responds, now you have an actual violation. So that's why we say don't copy all of the board members, because it's only natural that somebody's gonna respond, and then you're gonna have a Brown Act violation. So in this case, same example, board member A sends an email to all of the board members, B, C, D, and E. Board member B responds to board member A and copies board members C, D, and E. And now you're on the verge again of a Brown Act violation. And then if board member C, D, or E responds, now you've got a definite violation. So that's why you have to be very careful about how you send out emails. As soon as you have 3 members of a 5-member board participating in a series of communications of any kind, then you've got a violation. It's most likely to happen with email, but it could happen on a conference call. It's not unusual to have conference calls, but if you're all on a conference call together, and you're all participating, and even if you're just listening, because it says here, if 3 of you are on a conference call, then you're gonna have a violation of the Brown Act. But to reiterate, individual contacts or conversations between 2 board members, those are not prohibited. Or, one board member talking to the superintendent, that's not prohibited at all. Did you have a question? Oh, sorry, I thought I saw a raised hand there. Okay. So what are some of the exceptions? There's a few exceptions to this definition of a meeting. It says the majority of the members that can attend a conference or a similar gathering. So for example, if you go to the CSBA conference or CSBA convention, that would be an exception. But you have to be careful while you're there. If you all sit together and you start talking about business, then you could have a Brown Act violation. So you're listening to a speaker who talks about a subject that's germane to what you're doing. So let's say they talk about a new curriculum, and you're listening to the speaker talking about this new curriculum that's being developed, and then you all are there and you start saying, oh, maybe that's a good idea, maybe we should adopt that here in Laguna Beach. If 3 people of the 5, 3 of the board members hear that comment, that's a violation of the Brown Act. So it's always a good idea, either just, if you do sit together, limit your conversation, or just 2 of you sit together, 2 of you sit at another table to avoid any of those issues. Another example is attendance at a legislative body at an open public meeting. So I understand that you were at the city council meeting earlier. That's another exception, to meet with the city council, so long as that's properly noticed and properly agendized. Purely social or ceremonial occasions, that's another exception, so long as you're not engaging in a conversation among the 3 of you. I mentioned open and noticed meetings like the city council meeting, that's not prohibited as well. So that's kind of the definition of a meeting. Before I get into closed sessions, are there any questions that anybody wants to ask about that part of the presentation?
Good. I was gonna say, so meetings are gonna happen, we all start picking stuff up in Phoebe's way. One of us will say something to one of them, start saying something, another one will listen in, but then we're all still here, right? And so even though we close the session, now we can all hear, so
That
we'd have
could
to
be
walk
possible.
off.
Yeah, you need to be careful, because that could possibly be a Brown Act violation, depending on the comment. You know, if somebody says, oh, don't forget your keys.
Right, but I meant like, we're still gonna like, something else is true, you make some comments, so maybe we're,
Yeah, well, I mean, if you, let's say you adjourn the meeting, and as you're walking out, you say, I'd like to talk about X at the next board meeting, because I'm concerned about, you know, this issue. And all the other board members hear that comment, yeah, that would be a violation. So that would be a conversation you should just have with the superintendent one-on-one. Or mention it before the end of the meeting. Usually, I don't recall on your agenda, but a lot of board meetings have a round table at the end. That's the time to mention this.
and actually, and sometimes it's just something, right, where everybody's talking about something else, but then something will come and I'm just, ooh, and I just walk off, because they might start talking about something that, right, but it's more of that, I mean, we all just need to be mindful, right, just
You have to, you know, try to be careful. I mean, sometimes there's an inadvertent comment is made, but, you know.
I think that's the only thing that has ever
It would
happened,
be
I just.
because I think usually we
yeah.
have three of us in one location after the meeting.
No, I think when we're all just tidying up, I just think like being mindful of, not, it's the only place I can think of, that.
Yeah, I mean, but, you know, casual comments like I'll see you at the next meeting,
Right, all it's just-
or, you know, I'm gonna go to the city council meeting next week, are you gonna go? You know, I don't see those, that's not direct school district business, but of course, the city council, if you then say, well, I wanna go to the city council to raise an issue with the city that affects the school district, now you're getting into a Brown Act violation. But if you just say, I'm planning to go to the city council meeting next week, no problem. But if you say, I'm planning to go to the city council meeting and ask them for more assistance with school security, let's say.
Right, then that would be.
Then and you've got 3 people present, that would be a violation.
Using the regular old phone system, if I'm talking to Peggy on the phone, it would be a violation, and if I said, last week I talked to Carol, and
Yes.
she, I was sure it was.
That's where the violation
Right.
comes in. So let's use the school security example. I don't know if that's an issue here in Laguna Beach, but it is in some districts. So you say, well, last week I was talking to Carol, you call Peggy and you say, last week I was talking to Carol and she's supportive of asking the city for more assistance with school security or school crossing guards or whatever it might be. Now you've got a Brown Act violation because now you've got 3 board members.
Well, so is the onus on, let's say I call Peggy and I'm gonna ask her something about safety, right? But Peggy's already talked to Dee. Peggy would need to tell me I can't talk to you about that, cause I can't give my comments to Peggy.
She could talk to you about it, but she shouldn't mention that she talked to Dee about it as well. You can have a one-on-one conversation.
chain it.
Yeah.
So she can just talk to me,
She could just talk to you.
and we can talk about the same exact subject?
Yeah, you could, as long as you don't mention
ever
it,
mention
what the
Dee.
conversation with
For
the
my
third
prior
board member.
conversation with Jim, or no, just kidding.
You just have to be careful, that it's just a one-on-one conversation.
Okay, that's different from my first meeting, the first training I had, which is a different.
Well,
But not
they do
maybe,
try to get you to be
They're
cautious.
training not to, like, that I would not have a conversation with Peggy if Peggy already talked to me, that was what we were trained.
Well,
Or
it's,
new school board members at CSEA.
yeah, well, I'm sure they're just being cautious because it's so natural to say, well, I talked to Dee about this last week as well. And she said, you know, that's why they want you to, but you won't always know that. You know, unless the other board member, you wouldn't necessarily know that Peggy talked to Dee about the same subject. Unless she tells you.
But if we all, but then if Jen calls
I think
Peggy and
when you
talks to
said
her
that-
about, then Jen,
I think the advice of CSEA was just be overly cautious, so you
Okay.
wouldn't get into.
Yeah,
that.
I mean, because I think that's
Okay.
exactly it. They wanted you to be overly cautious because it's natural to say, oh yeah, I talked to Dee about this as well. And then now you're on the verge of a Brown Act violation, and if you say one more thing after that, that is a Brown Act violation. The other way to handle
talk to
it,
each other,
you could talk to each other and just, you can always
And
say,
gather
why don't we put this on the agenda for the board meeting and talk about it at the board meeting? I mean, you could always say that, and then it just goes to the board meeting. Or if you just have a one-on-one conversation and no third board member's ever mentioned, then you're okay, you haven't violated the Brown Act.
so we can call each member and say, I wanna put something on the agenda, as long as we don't tell them we call each member.
Yeah, you could theoretically, but you're getting so close.
That example
You
is
gotta be
very
very
different to
careful.
the-
Well, I know, but that's what I'm like, that's a slippery
The best
slope
thing
between
to
those
do-
two comments.
That's why they say, that's
Be
why
cau-
you
be
be
overcautious.
be overly cautious.
Yeah,
Because
that's
it's easy
what
at that
that's
point to say,
Yeah,
you know, you're now holding information and human nature is going to be, well, yeah, Peggy said the same thing. There you go.
and then you got a violation. The best thing to do is talk to the superintendent and say, I'd like to put this on the agenda,
Right.
and then the superintendent, you know, can have a one-on-one conversation with each board member to see if there's, you know, sentiment to put it on the agenda, or I'm not sure, some districts have a policy that allow individual board members to put things on the agenda. Or I noticed you have on your agenda, you're soliciting, suggestions for things to put on the agenda for the next board meeting, which is a good idea. Because then that takes care of the need for any conversations between board members. So I know it gets complicated, yes.
I know last week we were discussing, there was a group in town that wanted to meet with us the week before they had met with city council. And not to ask questions, I mean, they prefaced it, this is just to meet city council and, so we know you by name and you're familiar with us because we want to do nonprofit, we want to serve the community. And they asked us and we were uncomfortable if meeting with them, but there was question about that.
Well, there's a couple ways you could handle that. You could meet individually with them, two of you could meet with them. Or,
I mean, it's a big group of people.
okay.
They wanted like a mixer, that's my best word for it, right?
Yeah.
Okay, well,
It's like
a social,
events.
it's a
It's a
social
social
occasion,
event,
you
yeah.
could, that's one of the exceptions,
But the
Purely
political
social or
organization,
ceremony.
most of them have young children in our school district, and it just, I'm the one that was actually saying we should go ahead and bring it up when we're meeting with you this week, because it's probably not illegal, but it just has that opportunity, if they bring up a topic and then one of us responds to that, and then they talk to somebody else, and then they talk to somebody
it
else,
could, yeah.
and then they're putting you, they wanna know an answer. So I don't know how you avoid that and still, what their request is to get acquainted. But my experience as a board member is often in that kind of setting, they wanna get acquainted, but then they wanna talk about their issue.
Sure.
And then
Well, certainly it's okay for them to just get acquainted, that's more of a social occasion. Let's just use the crossing guard example. So let's say the parents from my elementary school, they want a crossing guard by the school. And so they start to talk about that issue. You can either, suggest that they talk with the superintendent about it, or meet with the superintendent, or you can invite them to come to a board meeting to do a formal presentation. You could, or an assistant superintendent if it's not the appropriate person. Usually those are the kind, if they have a specific issue, you have staff take a look at it, work with them, and then maybe they come to a board meeting and do a presentation.
So then the advice would be on us to not give our opinion or information, but tell them where they can go, have
Yeah.
interest, as we would in anytime someone came to us.
And then that, at some point, you maybe come to a board meeting, do a formal presentation that then we'll consider it at a board meeting. And listen to what you have to say, we'll have staff give input, and then, because let's say a crossing guard, for example, you need to talk to the city, the school principal needs to weigh in on it. So there's a number of issues, you wanna gather information, not just from the group, but from other sources as well, and then discuss it at a board meeting.
So in this case, they said it was not going to be about any issues, it was more just,
But if it's just to get acquainted, then it
Just
falls
get
under that
acquainted.
purely social type of activity. If they just wanna talk about your family and your background and how long
Right.
you've lived in Laguna Beach,
right,
and,
and tell you about theirs,
yeah, and tell you about their kids and their family and,
right.
I'm gonna name for the president.
you know, like to tell you about their kids and what they think about the school and the teacher and the principal, those kind of things. You certainly can listen to that stuff.
Okay, and one more, so if as a board member you share information with the superintendent, is the superintendent then allowed to share it with other board members?
Typically, the superintendent would share it with the individual board members or possibly share it at a board meeting with the discretion of the superintendent, depending on what type of information it is, the nature of it. Sometimes the superintendent sends out a board report before the board meeting or puts the item on the agenda. depends on what the nature is.
When we tend to, like, if we ask questions in writing, then the questions are pertinent, we share this, but we all have the same information.
Yeah, I mean, that's, usually the usual practice, is superintendent will want all the board members to have the same information. It just depends on the nature of the question. If it's, what time is the city council meeting next week? That's not necessarily something we need to share with everybody, but if it's more involved than that, the superintendent would probably share it with everybody. Okay, well, if you think of any other questions, we can come back to this topic. That's usually the topic that has the most questions. But the next set of slides has to do with closed session. So you're probably familiar with this. Prior to holding a closed session, you have to disclose in an open meeting the items to be discussed in closed session. And then the discussion of other items is not permitted, so only what's on the agenda can be discussed. And anything that should be discussed in closed session should be discussed in open session. So for example, this presentation is not something that would be authorized in closed session, so it should be done in open session. A couple weeks ago, I was at a board meeting in another district, and they had a vacancy on the board due to a resignation, and so they were filling that vacancy. All of the interviews of the potential candidates have to be done in open session for them. There's no closed session exception for that. So that was done in open session. So only specific items that are listed in the Brown Act can be done in closed session. So for example, you can receive advice from district's legal counsel regarding pending litigation or initiate litigation. But it used to be much broader than that many years ago. You could just go into closed session to receive advice from your attorney. That's not the case anymore. It's limited to receiving advice regarding litigation, pending litigation, or a possible initiation of litigation. The personnel exception, which we commonly call the personnel exception, allows you to consider appointment, employment, evaluation of performance, discipline or dismissal of a public employee, or to hear complaints or charges brought against an employee. So I'm sure you've been in closed session on those types of issues. That's a pretty common closed session item. The evaluation of performance can include consideration of criteria for evaluation, consideration of the process for conducting an evaluation, or other matters relating to the evaluation. So the courts have ruled on that issue. There's been some litigation over that, and they've said that if it's involving how you do the evaluation or the methods of doing the evaluation, you can discuss that in closed session as well. And that usually comes up in the context with school districts of a superintendent evaluation. That's where most of the litigation has been, or with the city manager, with the city council. However, they said you cannot discuss under the personnel exception salary. So when you get to the salary, you have to then come out and discuss that in open session. So you can discuss the evaluation. You get to the point you say, okay, the superintendent's doing a great job. We're really happy with his performance. Let's talk about the salary, but let's go out in open session and talk about what that salary should be. And then the public can then hear about that discussion in public. So that's come up a few times, and they used to be mostly court cases, but then they've added that directly into the Brown Act. When there's negotiations that's still being negotiated, if the usually in a larger district, management employees might have a representative representing them and negotiating with the board. But then those kind of negotiations can take place in closed session. But normally, with most school districts, particularly the size of school districts in Orange County, it's usually a discussion of the evaluation of performance. You get to the salary, and then you come out in open session and you talk about the salary. Now, when you talk about the bargaining units, the certificated and the classified bargaining units, that can be discussed in closed session with your representative. So that could be your assistant superintendent, that could be your superintendent, or you might hire somebody from the outside to do your negotiations. And then you can talk about your position in those negotiations vis-a-vis the bargaining units. And that includes salary, fringe benefits, and so on. Because as you can imagine, if that had to be done in open session in public, it would be very difficult to negotiate an agreement. And so, purpose of that is so that you can evaluate your position, instruct your representative regarding the negotiations, and then you can, like in closed session, you can also indicate a tentative agreement, but formal approval has to be in open session. So you could in closed session, if you're close to agreement, indicate through your representative, yes, if that's the terms that the bargaining units will agree to, we will agree to that as well. Let the bargaining unit know, and then final approval would be in open session. So you've probably gone through that process before. Okay. And you can talk about available funds, but once you start talking about budget, then you have to do that in open session, and that gets a little tricky. So for example, it's not unusual for you to talk in closed session about salary increase for the employees. So let's say the union is saying we want a 4% increase, and you've already offered them 2%. So now you're trying to reach a settlement, let's say between 2 and 4, just to pick numbers arbitrarily. So one of the questions that frequently comes up in closed session is, okay, how much would it cost if we, offer them 3? What would be the cost of a 1% increase? And that's fine to talk about in closed session. But then once you get into a situation where you say, okay, if we're going to do that, let's say that costs $500,000. I'm not sure based on your budget and your size, whether that's an accurate number. But let's just pick a number out of the air. So you say, okay, well, that's going to cause a deficit in our budget. So now we have to say, okay, where are we going to cut $500,000 to pay for this increase? And then if you start talking about where you're going to cut, that's got to be an open session. You cannot talk about that in closed session. So a number of years ago, I was involved in, I got involved after the fact, but the school district got in that very situation. They were close to settlement, and they were talking about how much it would cost to, up their offer by 0.5%. They came up with a number. Maybe it was 500,000. That's why they have that number in my head. I don't remember, but so they came up with a number. So then they got into a conversation in closed session about, okay, what cuts will we have to make so that we could pay that salary increase? They decided in closed session that they would close their continuation school. That would save enough money to pay for this salary increase. They came out of closed session, there was nobody there. They announced in closed session that they voted to do the increase and to close the continuation school. That was put into the minutes, and then a few days later, it was brought to the attention of the local newspaper by somebody in the public who saw the minutes that they're going to close the continuation school. And then the parents of the kids in the continuation school got upset, said, hey, wait a minute, this wasn't on the agenda, we didn't know you were going to do this, you didn't get our input, and you can imagine the ruckus that it caused. And so then it ended up in a lawsuit. That's when I got involved. But so it has to be done. Once you get to the point where you're talking about budget priorities and if you have to make budget cuts or budget changes, all of that has to be done in open session. And you have to publicly report any action taken in closed session and the vote or abstention of every member who was present. So if you took any action in closed session, you have to report it out. And then there's a new provision that took effect recently, this past year, that if you're talking closed session about approving contracts for employees, and those include salary increases and increases in fringe benefits, those have to be reported out orally as well. Not just the fact that you approve the contract, but the details of the contract, the amount of the salary increase, any increases in fringe benefits, and so on. So that's a new provision that was just enacted this past year.
So
increases or decreases, is that what you mean?
Yeah, I think, well,
Any change.
typically
Any
there
change.
increases, but yeah, any
Right.
change in
Okay.
employee compensation for management employees would have to be reported out. And then any documents that are approved, those have to be made available, so if they're employment contracts or collective bargaining agreements or settlement agreements of litigation, agreements to purchase property or sell property, those kinds of things, if those are approved, have to be made available to the public upon request. And then you don't have to keep minutes or records of closed session, just open session, whatever you report out. Any questions so far?
So those settlement agreements that are reported out, is that settlements for bargaining or settlements
That
for
could be-
litigation?
It could be both, either one. It needs to be made available to the public. Now, sometimes it's not quite in final form. So you have to put it in final form in a timely manner and then make it available to the public. There's no exact timeline, but you take a collective bargaining agreement, maybe it's just marked up and everybody's agreed on it, but it just needs to be typed up. So probably within a few days, if you finalize it and make it available to the public. But 30 days would be too long for something like that, but something reasonable, a few days.
You're voting on the final agreement in public anyway,
Right.
so does that apply to the tentative agreement?
I'm-
Does that apply to the tentative agreement?
Yeah, I mean, let's say on an evening meeting, you approve the tentative agreement. And it's
In
not
closed
quite, in closed session, you report it out,
Okay,
in open session. So that document would be in public record. It might, if it's in final form, then you have to make it available so the public can see what you voted on. The understanding that it's tentative because the union has to approve it as well. But, let's say it's not quite typed up yet, it's got handwritten changes on it or something. You can, take a day or two to, get it finalized, typed up in that sense, so that the public can see. But it should be in a fairly timely manner.
as far as litigation settlements, then are there ever times when parts of those are still remain confidential?
It could, yeah, if, let's say it involves a student. If it involves a student, you could redact, information, identifiable information. But the.
And that's public on request, not,
Yes, on
but
request.
not other than that.
Yeah, we wouldn't typically release the name of the student or the name of the parents, because if you release the name of the parents, it could identify the student. And so all that type of student records are confidential records. But if it's settlement of a tort claim, that's usually a public record. You might redact the names, but let's say it's a payout of $10,000 for somebody who had an accident on the property. You might not report out the name if it's a student, but you would indicate the amount of the settlement.
So, and I don't know this, but settlements no longer can have a stipulation that the amount cannot be revealed?
No,
No, okay, that's gone by the wayside,
yeah.
okay.
There was a case involving the Board of Supervisors in Orange County where they didn't want to release the amount of the settlement. But the court said you have to release the amount of the settlement. They did allow them to redact the name of the person involved because of the confidential nature of it, but it usually involves minors is the reason that it's confidential.
So is that only, because that's only recent, somebody can't go back years ago and find out how much a settlement was?
Probably could, yeah, because they've said these are public records. So they might be able to, I couldn't say for sure, but this case is involving the Board of Supervisors was a Court of Appeal decision. It's probably about 20 years old now.
Oh, wow.
I forget the exact date, but it's been a while, so, typically people aren't looking for settlements that are more than 20 years old, but you might be able to get one that's older, possibly.
And then I saw a question, and I think I understand it now from your slide 25, but the question was, not that one, but a couple back. When you come out of a closed session and a decision was made, somebody asked one of the board members, what was the decision as they're coming back? And the board member said, the board approved this decision, but I didn't. I didn't agree with it. And the question was, was that breaking the Brown Act? And they said no. A member could say, I didn't support the decision.
Well, yeah, you could, because it's supposed to be reported out,
By each person,
So-
and so somebody
so-
could say, I didn't because of these reasons.
I mean, it could be the board president, a lot of times it's the board president, or sometimes it's the board secretary who reports out what happened in closed session. So they would typically say, the vote was 4-1 to approve this agreement. And if it was you, for example, Ms. Perry voted no, and the other board members voted yes. So, some type of oral statement so that somebody sitting in the audience would know how everybody voted, and then it would be recorded in the minutes.
Knowing how they voted is, but the rest of what she said was that giving the reason that they voted.
Yeah, but then are you allowed to give the reason?
They're coming out
Out
of
of
the
closed
session.
session?
Because then
Well,
you're revealing a discussion that took place in closed session.
you gotta be really careful about that. Because you're talking about if you get into the substance of something that's confidential from closed session, now you're violating the confidentiality. But if you just said, I voted no because I didn't agree with the majority point of view,
And not give your specific reasons.
yeah, then I think you're okay, because it's kind of obvious on its face. Because you voted no, you must have
Yeah,
disagreed.
you just said I voted no,
But-
that pretty much covers it.
Yeah, you certainly can say that. But let's say it's a slip and fall of a minor at the, at the high school, and they sued, and you settled it for $10,000, and you come out and it's approved 4-1, and the board member who voted no comes out and says, I voted no because I didn't think this student was, and you name the student and you say, I didn't think he was really injured, I think he was faking it, I didn't think he really broke his leg. That's confidential information, and now you're opening yourself up to liability and you're violating the Brown Act.
Right. I think in this particular case, it had to do with buying some property maybe.
You could indicate you disagreed with the decision,
But just leave it at that.
yeah, I would just
Okay.
leave it at that.
Thank you.
Let's see, okay, so, action, if you take action to appoint, employ, dismiss, take some type of employment action, you should report that out. So let's say you appoint a new principal for the high school. So you voted, you can come out and you can, indicate that, what the vote was and that you voted no. Let's say it was a split vote again. So, you can certainly say, well, I disagreed with the appointment. From that, it's pretty implicit that you didn't, once they announced the name of the person who's appointed. But, if you start getting into like personal attacks against this employee, I don't think this employee is qualified. I heard rumors that this employee had, engaged in unprofessional conduct at his prior employment in another district. Now you're opening yourself up to liability. So you gotta be very careful. When you're talking about dismissal or discipline, you also should be careful about what you say in session 2, because you can same type of thing. You can refer to them as an employee by number or some other identifier. If no action was taken, then you don't have to make any kind of. You should be careful about what you say about confidential matters. Okay, with respect to labor negotiations, you can report it out. Obviously, if you have an agreement, and again, if it's a split vote, and let's say 3-2 vote, and there's 2 dissenters, it's implicit in that 2 of the people didn't agree with the agreement. But you still need to be careful about what you say in open session. You shouldn't reveal any confidential information. So you can imagine what it does to the process if let's say you approve a 3% raise, and I had this happen in district, or one of the board members voted no, and then said, you know, you know, we could have given you a 4% raise, you know, we had enough money. You could just imagine how it undermines the credibility of the district, it reveals confidential information. Even though the union might have wanted a 4% raise, they might not appreciate it either, because then it undermines their credibility as well. I mean, it creates all kinds of issues. So that's, you know, the type of confidential information that should be kept confidential. And it's always a judgment call, and it's always an opinion as to whether you have the money, don't have the money, you know, should you give this 3%, 4%, you know, it's a matter of negotiation. I know that's a touchy subject, but you know, there's a reason why this is kept confidential. And the same on the union side, you know, although they're not subject to the Brown Act, there's a lot of things they like to keep confidential on their side of the equation. Okay. You all can also go into closed session with respect to student discipline. That issue comes up sometimes. If you have an expulsion, or you have sometimes an inter-district appeal, or comes to the board, depending on your internal process, but a lot of confidential information can come up. So for example, you have a student who wants to transfer to another district, and the reason is because they're being bullied. If it's in closed session, they can give you the details as to what happened, but it might be embarrassing or humiliating. You don't necessarily want that kind of information out in the public. And they might name names, because they tend to be angry, and so you don't want them to mention other people's names in public either. Okay. So what happens if you do disclose confidential information? If that information was truly confidential in compliance with the Brown Act, if it was an employee, they could be disciplined. If it was a member of the board, it could be referred to the grand jury for review. So it could be some pretty serious consequences. There could be, you know, depending on the nature of it and how serious it is, the employee could be required to receive training, and Brown Act could be, like I said, disciplined. It could be turned over to the district attorney for prosecution, or to the grand jury. So there's some real ramifications to revealing confidential information. Any questions on that before we talk about? Yeah.
One of the disciplines I heard of in another district having to do with closed session and the whole board, and that the discipline was their meetings had to be recorded, and somebody then had access to listen to them to see if they were properly discussing things that should be discussed in closed
Yeah,
session.
if you have a complaint that Brown Act was violated and things were discussed in closed session that shouldn't have,
Right.
And it goes to court or the district attorney pursues it, they can do it in a civil action or in a criminal action. A lot of times the court will issue an order to require that board to record all of their closed sessions, so that if there's ever a dispute
Read
later,
that, yeah.
you can listen to those recordings to make sure that the Brown Act was followed. So yeah, that's one of the remedies under the Brown Act. Doesn't happen too often, but it does happen.
Discussion on a topic within closed session. The discussion that takes place among the board members in a closed session, is that confidential?
If it's an appropriate subject
Okay, it's a
matter,
subject that belongs in closed session.
yes,
So if
that would be
a board
confidential.
member then discusses with someone, you know, outside that meeting, we discuss this and that would be a violation.
Yeah, it could be, yeah. For example, let's say you're considering hiring a principal, and you have a discussion about the references that principal got from prior employment in another district. And let's say most of it's positive, but there's one or two negative comments in there. Then let's say a board member breaches that confidentiality outside of closed session as part of the appointment process, that would be a violation.
my understanding over the years is it was pretty much anything you talked about in closed session that was legally to be in closed session
Yes,
was to be held in confidence.
yes,
And that you didn't give that away to someone else as far as who discussed what or who said what. Pretty much anything
Yeah.
belonged in there.
Mhm.
And it was a really serious infraction if you do that.
yes. Well, if, the district attorney could prosecute for, either civilly or criminally. Yeah,
I mean-
Brown Act is very clear about that if it's appropriate for a closed session, it should be kept confidential. Okay, what about disorderly conduct during open meetings? If you have, disruptions or people, disrupting the meeting, there are certain actions that you can take. You can, require clear the room. If you have media present, media will remain, but, you can, then adjourn and then come back once the, situation has calmed down. So I think those were the main things that I talked about. One of the things I didn't put in the slide that we just touched on is that there are criminal and civil penalties for violating the Brown Act. And the district attorney of each county has the authority to investigate and to prosecute. And there's various remedies that can be taken. One of those is recording in closed session, an injunction ordering you to follow the Brown Act. So there's a number of remedies that the district attorney can employ. Also, any member of the public can sue for a violation of the Brown Act. They have to send a demand letter first, give you an opportunity to cure that, and then if you don't cure it, then they can go forward. If you cure it, then that's the end of it. So sometimes there's an inadvertent violation. I've had a few cases where the agenda wasn't quite clear, and somebody complained about the agenda, so then we put the matter back on the agenda for a future meeting, had the board discuss the matter again, and then that was the end of it. Usually it's something that's inadvertent. So that was overall the presentation. There are a few topics I didn't cover that you might have questions about. I'd be glad to answer any questions.
I noticed in the one section when you said that the board could choose to record or keep minutes of
You
the
can.
session. And my experience has been, there was a time in this district when they did that. It's a long time ago, and they came under separate cover. We were to review them, initial them, and hand them back in. We didn't keep those minutes. Ever since then, the legal advice to the district has been don't do that.
It just creates problems. It's better not to, it can lead to, issues of trust and so on. It might damper candid discussion. You might need to have some. One of the reasons for having closed session is to allow candid discussion, particularly with respect to personnel matters, litigation, that type of thing. And so, if it's gonna be recorded or minutes are gonna be taken as to what each person said, then that might damper the discussion.
I'm just asking that because I noticed that you had that it was allowed,
Yeah,
but I wondered if the overall advice was that it's not.
our recommendation is not.
Thank you.
Okay, well, thank you very much. It's been a real pleasure.
Thank you. And so we have, moved to item 13, board member requests for items for next meeting, requests for information or general comments. This is from Dr. Kelly. Anyone else?
Oh, I have nothing.
Go ahead. Okay.
So wait, are you talking about that? No, you go ahead.
I always thought we went in order, Dee, so I'm with you. I always thought
So,
the new hot is.
and this is not necessarily for the next meeting, but it's been called to my attention, and I looked, and in our big board binder, there are no bylaws in the 2000 series for administration. And I didn't have time to look at them all, but I noticed that Capistrano, Irvine, La Habra, Newport Mesa, Orange, South Bath all have those, and ours is blank. And I just wondered why ours is blank and
Bylaws or policies?
Hmm?
Bylaws or policies?
the 2000 series.
But if you're talking about the big policy book,
Yeah,
that's our
I'm
policy.
talking about the policy book. And we have none in the 2000s, and I have gotten some questions about why those were not on the website, so I looked at mine, and I said, well, I don't have them in my big book either, and I thought that book had everything. So my question is just, why don't we have them, and should we?
What are the 2000s?
It's about administration, it's mostly about the superintendent and his role with the board, et cetera.
So that's an information request.
As to why we don't have one, and maybe a discussion about if we should. It looks like all the other districts do, and there are some good things that,
Discounting other districts as far as here, is there an agreement that you want that information? That's
As to what the 2000s are and
right.
why we don't have them.
we've got all the other
I'm not sure
things.
why we don't have them, but I can tell you what they are. We don't have them, I don't have any constitution why we wouldn't, if they existed, so we have to provide that.
Well, about what they are, but not why we don't have them. But maybe
I'm
Jan
first
has
curious
that.
about what they are.
Yeah.
I'd like to learn what they are.
And then maybe Jan,
So
should
it
give
gives
some
a-
background on why we don't.
Information becomes an update, and then we can bring it up at another meeting if there's a desire to approve it.
Yeah, and get that even, or we can take action at the workshop. No, we'll workshop for that.
Yes.
And I get, well, not just what they are, I guess, but like, sometimes they're all redundant, right? Like, I guess that's, I guess it would be a lot.
Yeah, some weren't, but some were, but
Okay, anything else?
Okay, so then, the bringing of the 9000s forward and making those a priority. And I was thinking that since we have a new member, as a remembering me, new member, because this was new members now, in general, right? Is that understanding our 9000s and, what powers we give to the superintendent, what powers we keep, and, you know, all those things, is very informative. And it is how we create our protocols. And so the discussion of all of that, I think is vitally important, and I know there might be some policies that we need to discuss, but I was just gonna state that having all of those, and if we have time to discuss the protocol piece, not bring it back, but to then bring our bylaws back as information and as a whole, bring our, you know, right, to talk about whatever it is that we agree to. And I think then it's important to bring back then the protocol we created, so
That's
That's
considered,
right.
we
Right,
will,
but I-
that's in the future.
But if we're not, even if we're not changing those items, do we still bring them back for a reading? I guess it's kind of, right, so if we discuss in a workshop all of our 9000s, but we only change a couple, do we still bring them all back? I guess that's as information item.
Do not change it.
Well, we can bring it as information, I can just simply say these are the 9000s, and then.
We discussed these.
So we discussed.
Because I'm trying to do the reporting
She's
part.
asking if they all come as first reading, if we don't change it.
No,
No.
it's not a
So
change,
it's the
but
only thing that they're all coming in front of the recording session. Make them think of, okay. Let me see, where's my word for that? The other thing that I am looking for consensus on is a memo from staff to be provided as an update on, and before we have our workshop on, just for better clarification of some of those bylaws, but around the topic of board meetings. So we understand, Ed Code states requirements for meeting as a unified school district. We discussing the bylaws, right, so when we post the dates and so we have to determine scheduling, so this doesn't creep up on us again and we're shocked about how this works, right, so we understand how the scheduling dates work. And, staff requirement for advising the Orange County Department of Ed and the state of those meeting dates, so that we kind of just get a understanding of the annual organizational meeting what we need to be thinking about before that meeting.
Policy, right?
It's a code law.
There's EdCo,
But I
well,
mean,
yeah,
it's-
I've read the law.
We do have a board policy that says when we will hold our meetings, there's also ed code that states, gives requirements for meetings, and there's also requirements that we have to send to the county and then they forward to the state.
Right, and there's that 15 days to do that. Well, but my thought is, those meetings that we have, and, I don't think we ever on that evening, we've had a discussion before, determine whether we have too many or not enough meetings or whatever it might be. If we don't understand all the meetings and the meeting for the 5 of those meetings, like special meetings, superintendent meetings and stuff like that. And I don't have a clear understanding.
You mean the secretarial notice and is that what you're talking about?
Well, yeah, to answer the question about our travel and stuff like that, I just kind of felt like there's a piece of the pie we're missing.
But that's a policy, that's gonna come up in the policies. So I'm not clear what you're asking
Well,
for.
Well, now we are reviewing all the policies, which I guess when I first wrote this, I didn't think we
Okay.
were.
Okay.
Right, so that is true, now we are reviewing all of it, we'll come up with that. But I guess what I just wanna have understanding of, if we didn't have, on 6 months out of the year, we didn't have 2 meetings on those 6 months, and then one meeting, what we could do with that extra meeting date, like, would we not send that in and then just, it's our protocol that we would say we would have additional meetings, right? Special
That's-
meetings, others, and that to discuss
At the policy.
at the policy
That's
workshop.
policy.
Which would
Okay.
work
But
because
I was
it's part of
looking
the
for any
bylaw.
information we needed to have before that would help us understand. So I always feel like I end up staring at it and well, I don't know what the alternatives are.
Well, alternatives, you know, we could provide you simply with the organizational meeting requirements, the timelines for that and adoption of that. Beyond that, there are no specific requirements that I'm aware of that say you have to have these many meetings,
Not for you, but
not for you, but.
Oh, I thought there were something, I thought there was something, okay.
What's
We can
required
provide
is
that
that we
to you.
have to set those dates, the organizational.
Yes, I got that, but I couldn't figure out where the requirement was, how many we
We
have
can
and stuff
provide
like
that
that, so,
weekly, I think.
I guess that's what I was
the
missing was those-
Specific statements are.
yeah, cause that's
That's
unclear.
interesting, the rest of the board would have some clarity
Is there-
around that, I'm happy to provide that.
I'm fine with that. Information
Is it okay with that, getting that information?
understanding what the parameters are and all those.
And then I did ask Victoria, did you give me those things? The article? Just so that we, might read these before the meeting, I think it'd be helpful.
Before
The February 6th, yeah, meeting, and so, yeah. And so one of these is just, the forms of municipal government and to council manager government, is kind of what we have here and then in this. And we kind of run that way, so I thought this was really helpful in understanding how we run. This is just sorry. And then this is just from the Center of Public Education, and it talks about, the 8 characteristics of effective school boards. And then it discussed, how we need to be aware of our danger signs, things that might be moving in or out of that realm. And I thought it was just helpful as a background to our workshop on what we're creating. Because they're just highly in.
They are just saying it, I'm just letting you hear those, some of the dates referenced are pretty long ago, so just be careful that
I did not mean other dates reference, I just truly meant those
it
pages
was, things could have changed.
changed from that. Yeah, but they're,
So what state is this from?
well, they looked at all public schools, boards across the nation, and they just looked at what made effective school boards in high achieving school districts, and what made. What
It's
made,
2011.
yeah, and it's old, it's not that old.
Yeah.
But I just appreciated their effort, and a lot of it lies with the board, effective, highly effective school districts rely within the board, working together in unity. That's where they use. And so I just thought that it was beautiful. I know, in unity, it talks about in unity.
Okay.
And the last thing, I just want to, apologize to Member Perry, because she and I had a conversation at, CSBA, where she had asked me, if I wanted to be co-president with her because of my dyslexia, to not read out loud. And I very kind of her. I also thought that she did not want to be president. I
Just wanted to
apologize for
make
my
sure
miscommunication.
you had a chance.
I appreciate it. But, no, I did not intend it.
direction on the tabling motion, I think it would help if we got Robert's rules. We used to have that in the back of our agenda books, laminated in the back.
I actually pulled my laminate
So,
one today.
anyway, I think that would be helpful,
Yeah, it's awesome.
and that's all I have. Our next, regular meeting will be Tuesday, February 12th at 6 in the boardroom, and our workshop meeting is